this CodeX Speaker Series event. Actually, we benefit from a very large conference going on, the Empirical Legal Studies conference, which brought both Professor Dan Katz and Professor Josh Blackman into town. So we have, the privilege to have, sort of this back-to-back two leading legal technology scholars here who can share their work with us. So that's really wonderful. So today's talk, Professor Blackman, he is with the University of South Texas College of Law in Houston, and he's been there. He just started his career as a professor there, I think 4 months ago.
Barely.
He's also, previously clerked for the Sixth Circuit and for the Western District of Pennsylvania. And he's also founder of the Harlan Institute and the founder of the fantasy SCOTUS Net, the Internet's premier Supreme Court fantasy league. I think without further ado, I'll just turn it over to you.
Roland, thank you so much. I'm going to CodeX for hosting me. Today's talk is actually a very good follow-up to Dan's talk. Yesterday, Dan talked about quantitative legal predictions, how you can use data to predict cases. My talk is a little bit more focused. How can we use data about how courts operate to make attorneys make better decisions? This is what I call assisted decision-making. This is providing attorneys and non-attorneys with data about how courts operate and then letting them see what would be the best way to proceed. And I think it's helpful to go all the way back to Oliver Wendell Holmes, who said it quite well. Everything attorneys do involves predicting what will a court do. If I make this argument, how will a court react? If I want to win this case, what would I have to do? If a court said this in the past, how should I phrase my argument differently? And this is what lawyers inherently do. We look at precedent, we figure out what courts have done, and then we fashion arguments to appeal to those arguments to make things for the future. This works quite well when you're very familiar with an area of law, but any given lawyer can only have so much knowledge about a case. It's limited. When you start talking about big data and information, you can look at large corpuses of thousands of cases. I think every year in PACER, about 300,000 new cases are filed. No one can ever read all that information. It's impossible. But it is feasible to have algorithms that scan through those, figure out what's going on, and provide that information to attorneys to go forward. So there's a couple angles here, one of which is just legal education. Most people, when they think of legal education, have this image, it's a Norman Rockwell poster from 1927, of the law student hunched over a barrel, in the middle of the night, studying over law books. And this is a really antiquated view of the legal education system, but this is how a lot of people still view the law. And it really needed to be that way. Because we have Richard Susskind predicting the end of lawyers. We have these feelings saying that much of what lawyers do is what we call bespoke, custom. A lot of it can be automated and put in a way that can be distributed as a service rather than an hourly fee. So we're really, I think, staying at the cusp of what is law's information revolution. This was Professor Larry Ripstein and Bruce Kobayashi, whose Ripstein passed away last year, who wrote about using the law as data, using the law as a service that can actually be sold and distributed in a way to improve our ability to make decisions about how courts decide cases. And how are we going to get there? Through disruptive technologies. These are technologies that affect a quantum shift in the way people look at the law. For for decades, you had a thing like Westlaw or Lexis, and people thought this is the greatest thing in the world. But all Lexis and Westlaw did was take reported books and put them online. Only recently have they had a search engine that approximates like Yahoo in 1995. The searching functions of these databases are very bad. It's a heck of a lot faster than looking in a library, but still not particularly good. We need to fundamentally rethink how we access legal information, how this information is analyzed. One tool which I developed a couple years ago is called Fantasy SCOTUS. I'm a huge Supreme Court nerd in other aspects of my life. I love the United States Supreme Court. Fantasy SCOTUS is a Supreme Court fantasy league, exactly what it sounds like. You make predictions on how the justices will decide cases. In the process of building this league, we've accumulated almost 15,000 people make predictions. And we've turned this into a crowdsourcing market to offer predictions. By taking all of their various predictions, we can actually aggregate it and make a very accurate, almost an algorithm, of how the court will decide cases. Some of our best predictors are at 75% accuracy, and we know who they are. And we can look at them and weight their scores more heavily than less accurate predictors. And this allows us to have, a pretty good sense of how the Supreme Court will decide every case. Dan mentioned it yesterday, but there have been expert algorithms that have worked on this. And our crowdsourcing model is actually approaching the level of accuracy of our algorithms, which is pretty cool. And this is really building on the wisdom of the crowds. The notion when you have lots of people with dispersed information, you can make better informed decisions. And this is what lawyers tend to do. If you have an attorney, you only know so much. If you have an attorney at a firm, there's more information. If you have an attorney at a large firm, there's a bigger swath of information. But still, this information is limited by what they have particularly experienced in their private experiences. But going forward, the wisdom of the crowds is only finite. The reason why is because it's only relevant where people have information. When we're talking about Supreme Court cases, this is something a lot of people follow closely, and a lot of people have information about. Within the Supreme Court, we're actually pretty good. We had predictions about the healthcare case last year. And what's fascinating is we can actually track this on a day-by-day basis. And we actually see, on March 23rd in this oral argument, if you imagine a line going up from March 23rd, we have a sudden shift in how people perceive the case's outcome. Perhaps the most interesting aspect about this data is that we were not able to generate any kind of statistically significant results. We didn't know what was going to happen. We did not have any level of confidence in the outcome. And the actual model that actually happened, the Supreme Court pulled a surprise and upheld it in a very bizarre way. But in a sense, our users who had uncertain knowledge were able to actually forecast that, which is actually quite amazing. In addition, we have predictions for all 89 cases decided each year, and this is relied on by and we've been in the New York Times, Wall Street Journal, CNN, ABA Journal, Yahoo, and this has been all over the place. It's gotten lost a lot of really good publicity. But frankly, the starting point is only crowdsourcing. And this only gets you so far. The reason why is because people have knowledge about the Supreme Court. What my research focused on next, and also some other startup I'm working on, is how to do this for the lower courts. This is where the important aspect is. There are only 90 cases before the Supreme Court every year. The lower courts have hundreds of thousands of cases every year. Most attorneys will never, ever, ever make it to the U.S. Supreme Court. Lawyers go to the lower courts all the time. So the key is what I call assisted decision making. Using technology to understand, machine learning to understand what it is that lower courts are doing, how are they deciding cases, and how should attorneys be making the decision informed by that data. Getting there is going to be an interesting journey for a number of reasons. Perhaps the toughest one, from a technical perspective, is using natural language processing, machine learning, to figure out what is it that courts are doing. How do we understand it? How do we figure out how to make decisions based on it? Another preliminary problem is actually super crunching that data. There's a lot of information about the courts and how they operate. What I'm working on now, and I've actually made some pretty good progress, is making very sophisticated data trees and flows of how litigation proceeds from each step to the next. Figuring out, first thing, complaints filed, then there's a response, then there's a motion to dismiss. Mapping this out in a very sophisticated sense allows us to understand the flow of litigation at each juncture. And once we can understand that flow, we can start extracting the data. And with that data, we can discern trends and patterns and behaviors. How do certain judges behave? How do certain attorneys behave? Do certain firms behave in a certain manner? How do certain clients behave? And this is really a monumental leap in learning what courts do. One of the biggest insurmountable obstacles is something called PACER, which I don't know if anyone in this room is familiar with. It's the public access to court electronic records. This is the massive, disorganized, balkanized, horrible database the U.S. government has concocted for the sole point of tormenting data scientists. I'm positive. I'm pretty sure that's why it was created. I can't imagine. If they had any other goal, they could not succeed quite as well as tormenting us. PACER contains, on the order of magnitude, millions and millions of records of everything that happens in court. Every motion, every brief, every appendix, every document is filed in this database. But it's not just one database, that'd be too easy. Every single federal district court has a separate database that's indexed totally separately. They're not linked. They make it really tough. And if that wasn't bad enough, they charge you for it. It's not free. A bunch of data purists in this room would get appalled by that, but they're charging a dime a page. A page. If you download a 10 page PDF is $1. Where else on the internet are you charging per page? That's some relic of, you know, going to the library, making a photocopy in a Xerox machine. It's something for another world. But the court makes $100 million a year from this boondoggle, so it works quite well. So that's the technical cost, but there are ways of getting to that data, and something which I'm actually making pretty good progress with to help this go forward. So let's actually work with the assumption that we have this data. Okay? This is what it looks like. This is what PACER looks like. I don't know if anyone's ever seen it, but this is a standard docket sheet. I just use the Oracle versus Google case that's been in the news of late. It's this huge, huge, massive IP patent case that was on the federal district court not too far from here in San Francisco. Just by looking at this docket sheet, you're able to learn a lot of information. A lot. The court doesn't do a very good job in identifying it for you. They don't give you, tables. They don't give you relational diagrams. It's all kind of just plopped in one place. So let's just look at what we have. Going from top to bottom, we know what court the case comes from. We know what the docket number is. We know who the parties are. We know it's Oracle and Google. Who are the judges assigned to it? Who are the magistrate judges assigned to it? The cause of action, the nature of the suit. These are codes that tell you what kind of case it is. When was this case filed? Is there a jury demand? Why is there federal question jurisdiction? That's just in the first paragraph. You don't need a human being to code that by hand. Westlaw and Lexis, their entire model is having human beings read these cases and manually code them. You don't need that. Machine learning can pick that up in a heartbeat. It gets a little trickier when we start looking at these. These are called the entries on the docket. Every entry is dated, and that little number with the hyperlink on it, that's actually a link to the PDF. And then there's a little, 2-3 sentence notation. That describes exactly what happened. So then we're talking more sophisticated machine learning. Think, okay, first thing first, a complaint was filed. Okay, complaint was filed, that means litigation commences. Why was it filed? Patent and copyright infringement. Who filed it? Oracle. What attorney filed it? Whatever the name is, right there. You know all of these things. You know the date. Okay. So now we see what happens next. Okay. Case designated for filing. ADR, that's the alternative dispute resolution. There are all these flows that happen. Litigation is not that unique. There are certain trends that every case goes through. And by going through enough of these, which is what we've been doing, you're able to figure out like a map, almost like a tree, if you will, of the various branches how things can go. There are only so many permutations of how litigation can proceed. So a lot of this is kind of cross-disciplinary. I was a federal law clerk for 3 years, and that's what I did for 3 years. I know this thing inside out, backwards, forwards. So I have a very good sense of how this works. But putting this into a machine language system and learning what it is gives you a very good sense of how things proceed. And once you know how things proceed, you can start making better informed decisions. Because right now, all the PACER data is going down the drain. It doesn't go anywhere. It's just sitting in a stupid HTML table that can't be utilized in any meaningful form. There's not much value there. So I like to use this analogy. If anyone's ever seen The Matrix, I love this scene in The Matrix. Neo is in this virtual world, and he realizes, I can do this. You have to view the law as data. You have to be Neo. Zeros and ones, that's where we are. I think there's some deeper philosophical questions about viewing normative decision-making and constitutional law and civil rights and immigration. I think there's some really deep, profound questions about how we can use computers to help with those cases. But what I'm doing now is much simpler at a much more abstract level. I'm just looking at the flow of litigation and how courts are deciding cases at an abstract level. Is a summary judgment being granted or denied? Is a judge letting a case go to trial or not? Is there a jury verdict? If so, how much is that jury verdict for? These are relatively straightforward questions that can be almost Boolean in nature. And you don't have to go into deep philosophical probings of should computers be deciding cases. That's for another day. My inquiry is focused on giving lawyers data on how cases are decided before them. So let's just break down one such flow. I already went through that top box, which gives a very rough summary of what happened. And the tree begins with saying, okay, there's a complaint filed. Why? Patent and copyright infringement. That's valuable information. Who is it filed against? Google. Okay, so now we know that Google, a company, and we can find something about Google, probably like Googling them, what was involved. Who filed it? Oracle of America. Okay, so now we know a couple things. We know Google, we have Oracle. Your database people, you can start viewing the little arrows going back and forth between them. Okay, what else? There's a cover sheet. There's an actual PDF attached to it. Okay, so we have this document, we have a complaint. In the complaint, there could be causes of action and things that they're suing over. That's a lot of information, just by looking at one level. The big thing that usually happens in a case is, the first big thing, motion to dismiss. For those of you who are not familiar with American law, that's asking the court to toss out the case before it goes to a jury, saying, listen, this case is worthless, get rid of it, toss it out. So the motion to dismiss is filed, and we know, okay, Google filed it. That's useful. We know that a motion hearing was set for roughly 2 weeks after the motion was filed. Okay, that's valuable. Not all judges have oral argument, but now I know this judge does. That's a style. So that's valuable. Okay? Then we see 2 weeks later. 2 weeks later. There was a memorandum filed in opposition to it. Okay, so now we know the flow. There was a complaint. Someone tried to dismiss the complaint, and then someone wanted to reply to that saying, don't dismiss it. So now we have this kind of flow, this tree, so to speak. Who filed it? Richard Ballinger, he's an attorney for Google. So now we know, okay, this lawyer is working for Google. That's data, that's valuable. Okay? Then, in pretty fast time, roughly 2 weeks after that, the court denied it. Okay, that's valuable. We know that this judge works pretty quick, or at least he works quick on cases involving Oracle and Google. Most judges let these things sit for months. But that was a pretty fast turnaround. And then we have the court's opinion. With more sophisticated natural language processing, we can figure out what was it in the court's opinion that found one side more persuasive than the other. Why did one side win and one side lose? Was it controlling law? Was it a factual issue? That's something which we can just ascertain by just looking at this flow. So you can really crunch data about so much stuff, about the cases, motions, the opinions, dates, judges. These are all things which are somewhat not easily, but they're somewhat available. All we have to do is just analyze it. Oops. So if you just want to put on your database hats now, this all begins really with the case, because that's what we know. People file cases in court. From cases, you can learn about courts. How many cases are filed in any given one court? Or, the other way, in this court, how many cases were filed? It goes back and forth, the arrows. In addition, we know something about judges. How many cases does this judge currently have? Okay. How many judges are in this court? Okay, so you can start making the arrows go back and forth. Sometimes judges sit in other courts, so how many times has this judge sat elsewhere? Okay. It gets even more complex. Firms. How many cases does a particular firm have in this case, in this court? Okay. How many cases does this firm have before this judge? Has this firm ever litigated before this judge before? More complexity. The case also has a cause of action in the nature of the suit. How many personal injury cases has this judge had in this court? How many IP cases has this judge had before this firm in this court? How many IP cases has this judge had for this firm in this court that went to a jury verdict? You can start elaborating on how deep you want these regressions to go. If you asked a junior associate at a law firm to do these same calculations, it would take hours upon hours upon hours, if not an entire week, to run those kind of questions. Most of the time, if you have a lawsuit filed, you're in a law firm, you want to find out about your opposing counsel or about the judge. You ask your buddy, hey, what do you know about Judge so-and-so? Or, hey, what do you know about the attorney at this law firm? They go, oh yeah, that guy's a jerk. Or, oh yeah, I went against that guy and I won a couple years ago. Say you ask 10 friends, maybe 2 or 3 of them actually know the firm. They might get very limited anecdotal evidence. The value of that is good, but again, it's not enough to be accurate. When you start working with a large data set, you look at all the cases filed in a given court, you can now say with some certainty that that firm has appeared before this judge 5 times. In 4 of those cases, they won. In 3 of the cases they won, they actually went to a trial and they got a jury verdict in their favor. Of the cases that got to a jury verdict, the judge was not willing to dismiss their key expert witnesses. So now you know with some detail how everything flowed. And that is very valuable. And these are the kind of algorithms and trees I'm developing. So that's just with firm. Then it gets even better with attorney. Okay. In any given firm, there are probably, 20, 30, 40, 50, 500, 1,000 attorneys that are registered to litigate cases. Say you're going up against a lawyer. You want to know, what's this guy's deal? How's he litigate? Does he settle cases at the last minute? Does he bury you in discovery? Does he try to file stupid, frivolous motions? Has he been sanctioned by a court before? You can develop profiles of the attorneys and figure out what it is they're working on. Parties too. You know that Google's getting sued. Where else is Google getting sued? Where else is Oracle getting sued? You can actually make, with some semblance of detail, who are the best parties for me to go after? What's their strategy? Do they usually just settle out? What law firms do they usually retain? Conflict of interest checks. Who are they represented? And even then, people. In the course of litigation, the names of people come up in various capacities. You can then use that data to figure out, who are these people? What are they doing? How do they interact with the courts? This entire framework, which I'm developing, is aimed at using all the data in the courts to bring some sort of information awareness, so that when you're an attorney and you want to make a decision about a case, you're not flying in the dark. You're not shooting in the blind. You can actually make, with some degree of specificity, decisions based on what's happened before. And this really will revolutionize the way attorneys can litigate. Because no longer are they simply restricted to whatever, their buddy in the next office over knows about a firm, or, what some 5-year-old file in a cabinet says about Judge so-and-so. Now there's real-time data about all these things. And this is really a significant leap forward, a disruptive technology, if you will, of how litigation proceeds. And I actually have a demo which I'm going to show you today. It's not publicly released, but I can demonstrate it for you today. This gives you just a rough estimation of how this works. I have some more cool stuff, but not showing it today. But this will be good for today. And I have a demo in a minute, but this is just some screenshots. So one of the biggest failings of Pacer, just from a UI perspective, is it sucks. It's very, to put it mildly, it sucks. It's very difficult to find stuff, it's not user-friendly, and attorneys tend to be the most Stone Age people imaginable with technology. They just don't do well with stuff. I mean, I swear, if you actually use Pacer, it's like using Alta Vista like in 1996, and that's what it actually reminds me of. It's just really an archaic interface where you have these bland text rows. So what I've done is restructure this into a very engaging interface that I think attorneys like, and everyone I've showed has absolutely loved it. Where you have tabs, people like tabs. What's the case about, who the judge is, the firm is the attorney. Rather than lifting stuff up and down, you have a timeline so you can zoom from left to right and figure out all the events in a case. And once these things are indexed in when I described the kind of document trees or decision trees, it's fairly easy to build these kind of things. You have a little preview of the doc right there. So you don't have to open the entire thing up. You can kind of see a preview right there. You have the brief description of everything that's going on. Timeline, you can zip through the entire litigation very quickly. You have some cases in federal court that have thousands of records. This is something which is not going to be used only for as a standalone website. I've been talking to people who do document management services and practice management services, and they're also interested in integrating this into their system. Because if you have a billing software, for example, it would not be much of a stretch to incorporate this in, so you can actually relate what are you working on to what's actually going on, and we're actually developing this going forward. Biographical stuff. Learn about the judge. What's his deal? What statistics do you have on this guy? Is he going to rule against you or not? What's his philosophy? Has he handled similar cases in the past? If so, what's going to do? Law firms. Okay, your case has Boy Schiller. There's 7 or 8 attorneys. Everyone knows who David Boies is, but the other people not so much. So you can research what they like, how are they handling cases, what has been their experience in federal court, what's their strategy. Are they going to just bury me in discovery? Probably. Are they going to try and file lots of frivolous discovery motions to compel? Maybe. Are they going to try and maybe bully you and then settle at the last minute? Some attorneys tend to do that. Attorneys are more predictable than you think. They kind of tend to do what works. And that only worked insofar as no one knows what their secrets are. And it's very easy to keep secrets because it's just not easy to find out what people do. Now we got David right there. Also, you can look at parties. What are the other cases Google's participating in? Okay, let me look if this works. Unfortunately, my computer projector did not work, so I'm going to have to do this in a little weird sense. Ooh, it works. Okay. So this is basically the website. Why don't I do it here? Okay, never mind. So this is the website, and this is roughly how the interface works. Rather than having everything on various one pages, you split it up. So the docket, over the judges, going about the firms, going about attorneys, and the various parties involved. Okay? The docket overview, this gives you a slide of how everything works. So this was the exact same case I mentioned before. When the complaint's filed.
How'd you get the logos in? Did you just manually import those?
There's a couple ways of doing them, but yeah, manually for the
Okay.
prototype, but there are more sophisticated ways of pulling
I
those
could
out.
see they weren't in the original source.
No, and there are some copyright issues with those as well, so this is just a beta. It's very likely that I would, fair use, I'm not sure how fair that would be. Because I can imagine, lawyer, think about these things. But yeah, you would have to get them from somewhere else. A Pacer does not have those. So you have basically a slideshow. So it's like Huffington Post, and you get clicks, where you can actually slide through the entire litigation. So you start with the complaint, motion to dismiss, the response to the motion to dismiss, the opinion denying the motion to dismiss, and you can scroll through this any way you want. Go all the way forward, summary judgment's filed. You can keep scrolling forward. The response. It's the entire litigation presented in a way that actually makes sense. And not only in a way that makes sense, but is very conducive to data and analysis and doing stuff with it. Okay? When did the trial begin? How long did the trial last? The trial began on the 16th, went to the 30th, 2 weeks. Jury deliberations. Was there a jury verdict? What was the verdict? Who's the judgment in favor of? These are all questions that can be answered straight from the docket sheet. Likewise, show you the other elements of the interface. We can look into judges. Who are the various judges in the case? Okay, in most cases, that was called a magistrate, kind of like an assistant judge. Who are they? Most people know about judges, magistrates not so much. They're appointed on a contract basis, we don't even know about that. Okay, we can learn about the firms. Who are the firms in this case? Morrison Forrester, big firm. You have Boy Schiller, you have King and Spalding. It's presented in a way that's actually very conducive to data analysis as well. Who are the various attorneys? Everyone knows who David is. The other guys. I don't know who the other guys are. And then we look at parties. We have Oracle, we have Google. And then from there you can branch off and figure who it is that attorneys are. So this is something I've been working on for a while, and I'm actually getting somewhat close to releasing this in a way that can start using. Pretty getting there closer. So that's just a benefit for you, early viewers today. This is something that really gets a head start on how this data can be processed. Lexis and Westlaw, they're just not doing this stuff. Their entire business model is premised on, having a librarian, they call them librarians, but they're basically reporters for the court, who read the cases, digest them, and write summaries of them weeks, if not months afterwards. That's their entire business model. And I'm not trying to compete with that. That's not That's not what I'm trying to do, because they do that very well. This is something different. This is about providing analytics of the actual litigation. So it's actually a service on top of it. And that will be coming fairly soon. Give you a little preview, and this is something which is kind of, I'm at Stanford, so I might as well go for broke. This is what I see being the next 5 to 10 years of this technology. And I think this is a wonderful tool, not just for attorneys, but also for non-attorneys. We talk about access for justice, of having people who don't have the means to hire an attorney handling their own legal problems. And this is something that's going to be very, very important. So, you know, I call it Harlan, you know, call it an intelligent litigation assistant. If you will, imagine this, unfortunately, the old iPhone 4, now that the iPhone 5 might slide out of date, but if you will, the iPhone 25, whatever exists in the future, you know, Steve Jobs from the grave makes a brand new iPhone that's, you know, holographic or something. But imagine an app, something like Siri. Everyone knows about Siri? Of course, you're in Silicon Valley, you know what that is. You know, you take out your phone, you say, Siri, you know, what's the weather like? Okay. It knows you're in Palo Alto for your location, so it gives you the weather in Palo Alto. Or it says, you know, give me directions to Fisherman's Wharf. It knows where you are for your GPS and can direct you. Based on information that you don't tell it, it can learn what you want to do. So say, for example, you know, someone says, I want to draft a contract. This is historically a question that a person would walk into a law office and ask these kinds of questions. I want to draft a contract. That's not enough information. You know, they don't know people don't know what they want. So an attorney would then be responsible for asking, okay, what kind of contract? What do you want to say? What kind of terms do you want to provide? You know, where do you want this contract to be enforced? These are the questions an initial consultation would usually yield. There's no reason why that flow, that decision tree I keep talking about, the various questions, can't be taught through machine learning. There's no reason why. So you go to your phone, you know, I want to draft a contract with, you know, whatever. I have some questions. The same style of questions that an attorney would answer can then be automated. And by each question will lead to a subsequent question, because it knows what you're looking. So, where will the contract be executed? That's a jurisdictional question. Each state has a different substantive law of contracts. That's a very big deal. Sometimes if a contract is written in state A and enforced in state B, there are other ways of limiting it. These are important things. You know, what remedies? Okay, once you guys have remedies, you can start going to other things. You want punitive damages? You want liquidated damages? There are all these branches of various questions which we can answer. Insurance. Insurance law is a big deal in contracts. What's our coverage if we get in trouble? These are the kind of questions that can be learned. And the way they can be learned is through this assisted decision making. By having a computer have access to large amounts of data about the court, the machines can actually learn what contract provisions are most often litigated. What contract provisions are most often upheld in court? Okay, those are the contract provisions. This can all be taught right in the computer. And really the cool thing is kind of a document production service. You know, can I draft a contract for you? You know, LegalZoom. Ask you a series of questions and have someone put together templates and stuff. This would be kind of like the next level up. It would be saying, we know everything you want. We don't need a template. We can actually generate it based on best practice of whether litigations work. This is kind of a game changer. You know, I don't think there'll ever be a need to replace attorneys. I simply don't. What I do think is that the amount of things that attorneys are doing custom will be severely diminished. You know, you're not going to hire a robot to argue for the U.S. Supreme Court. That's not going to happen. But if you need to draft a contract or a will or something that hasn't done 1,000 times before, there are ways of automating it to make yourself in a much better position. And really, from an access to justice perspective, I think this has a lot of salutary effects for society. I mean, imagine this question. You know, I'm actually from Staten Island, and where I live was just rocked by a hurricane. My aunt lived in Brooklyn, and her house was effectively destroyed. You know, she didn't know what the heck to do. I mean, she didn't actually have power or cell phone service. This would not have been too helpful. But imagine, you know, you have a problem. Tenant maybe not the most educated person, doesn't really know about lawyers, doesn't really know who to call, has a phone, says, hey, it's cold out, a landlord would fix my heat. That's a very simple question. And if you have to do the legal services, you'll be probably waiting online for hours just to ask a question. And sometimes people can't do that. They have jobs, they have work. They can't take off in the middle of the day to go to a legal services office. Or maybe they're a landlord or a community organizer or something. So they ask their phone. Okay, you have options. There's a tenant rights department for the city. Now, all of us might know that's an obvious thing to do, but if you're not educated, that might not be something that's obvious. And rather than just saying, here's, Google, and you could Google tenants right department, you wouldn't know to do that. You wouldn't know, I can't fix my heat. And the algorithm will say, okay, you can't fix your heat, you live in an apartment, that means you can call the tenants right department. And gives you the phone number right there. So now you just saved yourself an entire day of going down to, an office when you can probably resolve it with the phone number. Or, what if that doesn't work? Document production would not be limited to, it wouldn't be limited to just contracts and stuff. A demand letter. This is simply writing your landlord a demand letter saying, listen, if you don't do this, you're going to get in trouble. I'm going to call the city and they're going to fine you a lot of money. These are things which a legal services office probably has a backlog of thousands of these to do. But it's really the same template. You probably have a legal service attorney just populate the same template over and over again. There's no reason why the algorithm can't say, okay, we have a sample letter. We're going to fill in your name. We're going to fill in the landlord's name. We're going to fill in the exact problem, describe in a sentence or two. Bam. Maybe we can even email it to them or send them a PDF or something. This makes your life a lot easier. Or small claims court. Small claims court is kind of intimidating. What if the computer provided the exact algorithm of how this complaint should be filed in small claims court? It said, first you do this, you go to this building and this address, you file this form, you can link to the form, maybe it's filled out for you, you have to pay this fee, and you do these things. This is not something that's easy enough for a person to figure out. I've tried. If you go to any small claims court website, they're actually pretty confusing. But here, if it knows exactly what you want, you can fill it out. And, worst case scenario, contact the housing lawyer. Maybe the local bar association has a list of attorneys who volunteer. Plug those in, guys who say, I'm willing to pro bono work on housing issues. These are all of the issues that a person can confront, and you can learn more. The way to do this is by beginning machine learning. It's by teaching computers how you're going to analyze cases. Because once you understand how cases have been done in the past, you can do these kinds of awesome things and help people understand for the future. And this is really where things are going. This is something I'm very passionate about, both from an academic and also an entrepreneurial perspective. I've been doing fancy SCOTUS now for almost 4 years, and we've gotten lots of publicity and lots of attention. And I think the next big wave, and what I've been working on now for some time, is pushing forward with this understanding of the lower courts and making it make sense and helping attorneys figure out what's going on. How can they do their job better? How can they, perform a task that used to take them 40 hours and now do it in 45 seconds? This is really going to be a game changer for attorneys. And I'm very excited, Roland, that you invited me to come speak with you today. And I'm really great to see such a great crowd come out. There's a lot of stuff going on, so I really appreciate your time. I think that's it. My email address, it's not up there, but just joshblackman@gmail.com. So my name is joshblackman@gmail.com. I'd be happy if any of you would contact me in the future. I'd love to talk about this. It's a passion of mine, and I enjoy being excited and meeting people who are likewise engaged. And I welcome any of your questions. So thank you very much.
So you told us that Pacer isn't very easy to use. How are you using it to build your...
Secret sauce. Yeah, it's...
I mean, you paid to have access to...
I can't really talk about it here, but it's been something of a ordeal. But I was a law clerk for almost 3 years, and I got to know a lot of people in the court, so I've been able to work some stuff. But it's not an easy nut to crack at all, and it's something which it's not easy. But the actual, once the data is called though, once the data is pulled, then you're in business because it's straight up HTML, and you can run really cool stuff on it. It's unfortunate the government's put that stumbling block in front of you. It's tragic, but it's not insurmountable.
Wouldn't your competitors have access to the same information under the Freedom of Information?
No, it's not FOIA-able. And the reason why is because they say you can freely access it, you just have to pay a fee for it. I mean, FOIA existed for a long time, and in the olden days, if you wanted a document, the government could charge you a copy charge. And there's lots of regs that saying the copy charges are fine. For example, if you wanted a document from the Library of Congress, they charge you $0.05 a page for a copy. No one would object to that. And even under FOIA, I think they're in the regs they can charge some sort of reasonable rate of obtained documents. I think it's absolutely unreasonable the 10 cents a page charge they do, but I don't think, and people have tried this FOIA, it doesn't work. The courts make a lot of money off of this, a lot. I mean, I think it's 100 million or some crazy amount a year. And
A dime at a time.
yeah, it's literally nickel and timing you. I mean,
They got to pay for that judicial conference somehow, right? Oh, wait, that's on video. Strike that.
Yeah.
So are you developing the questions that are asked, or will someone be able to use your program and ask their own questions?
You mean the app, the one I showed there?
Um,
Well, I mean, the product I'm developing, you'll be able to run queries. And they'll be based on those kind of, that entity relationship thing, like you can look at cases, parties, firms, you can run queries based on those. So you could specify a specific judge with a specific court and a specific cause of action in a certain time constraint. You can run that query. So it will be pretty user-friendly, and you can figure out exactly what you want to do.
So,
The startup you're working on, is the service the company provides, is that for law firms, or does it also provide services to the public at large?
So the way I'm structuring this is going to be freemium. This might answer your question. All the opinions and docket sheets I obtain will be free. If you want the analytics, you have to pay for it. So any docket sheet or opinion I manage to download by hook or crook, that will be freely available. The government, can't assert copyrights on one side of a document I can then make available. So this is what will largely separate it from Lexis and Westlaw. They're closed. They don't have this stuff. So this will be a way that the information can be obtained. But the hook will then be the analysis. And that will be lucrative because firms pay for that kind of stuff. And that can be used by outside entities.
so I have 3 questions, like a small. Do you get this data on CD or through
Yeah,
website?
I'm not going to really talk about how I get it. Other questions?
But can you
By hook or
resell
by
it?
crook, he said that.
Yeah, that's
Well, no crook, but
no, that's fine. Whatever works for our startup. But the thing is, can you resell it? Because you are getting it through some means, and court might have objection if you start selling it and you start making money.
Yeah, I mean, I'm not doing anything that'll get me in trouble.
Okay.
I'm very careful about that. I'm very careful about that because if you get in trouble with the courts, you're not in good shape. So.
And then, what about human biases? So let's say someone did this analysis, I think last year, that for DUI, on average, a person gets, let's say, 10 years in prison. But DUI with manslaughter gets 20. It's one
I'm not doing criminal, by the way. I'm staying away from criminal. I'm just doing civil.
So I mean, in civil, you can have a bias, right? So I mean,
A bias from the court?
yeah, I mean, judges are biased.
Yeah, I mean, this is going to be a great tool for academics. Academics will be, and I will have I'm working a special license for academics that they can get at some, I don't know exactly how, but it'll be in a very easy way for academics to get access to it. I can't wait to see the empirical legal studies that are done based on this system. I'm really excited about it, because I mean, my full-time job is a law professor, but this is also cool
You should
stuff.
open it as an APIs.
No,
like
there will be an API.
Yeah.
There will be, and I just don't know what the terms will be, but there will be an API.
Sure.
And this will be the only such API that exists because the courts are totally, firewalled off. They don't have any kind of API. Yes, sir.
You said you were a clerk, and I'm wondering what the judges' reactions were to Pacer when you were working with the judges. Like, do they view it in the same kind of
I don't know what the heck it is. I mean, they don't, from the inside, they don't really think that much about it. Judges aren't usually the most forward-looking people. They're not too concerned about it, and if they were, they wouldn't have just raised the rate by 25%, from 8 cents to 10 cents a page. judges don't really, and really I'll put lawyers in the same grouping, they're not really thinking about the law as data. They simply think as Pacer as a way that they can have less paper in their office. You know, in the olden days you'd have all these files and cabinets and records and all this garbage, and now it's all online. It's crazy. But the judge I clerked for, if you want to sign an opinion, he would maybe print it out, he would sign it, then we'd scan it. He didn't like electronic signatures. He would actually print it out, 75-page opinion, he would print it out, sign it, and then scan it back in. These are judges. I mean, I'm not expecting them to be particularly savvy about that kind of stuff.
So would you explain a little bit more about what you mean by analytics? Can you ask your own question, or are you just going to provide preset questions, answers to preset questions?
Well, I mean, there are only so many things you can ask. So there will be certain parameters which you can search along. You can search along, you know, firms, you can search along cases, you can search along parties, you can search along attorneys, and then you could search for a specific name of an attorney or a name of a judge, a specific cause of action code, like hundreds of them. So there are ways you can search. It's going to be somewhat geared towards the very questions that people would generally ask. And I think if you wanted to do like a free-form query, you'd have to probably write that like in R or something, you know, something very sophisticated to actually do a generated, very specific query. But for attorneys with interfaces, they're going to be looking at cases, for courts, judges, firms, attorneys, those very broad umbrellas, and they can drill down within those.
Now, how much extensible your system? What it means that if you develop it for civil proceedings, how hard would it be for me to implement it for, let's say, criminal proceedings?
My hesitancy about criminal is I'm just very leery about putting that stuff on the web. Ethical issues, I'm not crazy about having all that criminal information available because a lot of really private stuff, if that gets into Google, that can be very damaging to people. So I won't be collecting criminal information, so you'd have to find that somewhere else. And you know, I guess you could use a similar framework, but criminal stuff is just very, I mean, maybe I would release aggregate criminal data, but nothing drilled down by, you know, search by the name of a defendant. That's getting to dangerous waters because if a defendant was acquitted, I don't want that in Google.
It means that you said every court has a different format that they're having this data. So it means you have to have different form of extraction for let's
Well, Pacer is more, I mean, they're different courts, but they're somewhat similar how they format stuff. It's actually not totally different. They're similar enough.
So what courses are you teaching now?
At my law school?
Yeah.
I teach constitutional and property law. At the school I'm at, we don't have any courses about this quite yet. I've only been there about 4 months, so working on it. Yes, sir.
Curious about, you know, obviously a big believer in this data-driven decision-making. Pacer's a pain, but beyond Pacer, it's nearly impossible. I mean, thinking about like down the road, have you thought about what it would take to get, you know, state and local dockets to just the process?
Yeah, I mean, that's Dan, my colleague Dan Katz at Michigan State. He's working with state courts and criminal law, and I think he's said it's absolutely a nightmare.
Yeah, it's hyper-federalization. Each of these states is their own. Within a lot of states, they have their own internal, like individual courts or their own internal IT fiefdoms. So
It's basically Lexis and Westlaw's biggest barrier to entry right now is their relationships with those court reporters.
Right, and that's why I'm only focusing on federal courts, and that's why I'm only doing civil, because criminal, there are a lot of other issues with criminal that make it somewhat troublesome, so I'm only focusing on civil. And even within civil, for example, like I'm not going to do immigration cases, I'm not going to do habeas cases, you know, like asylum cases, I'm just not going to do those. I think there's so much personal information, I don't want that going to Google. You know, someone had some sort of asylum claim for, you know, rape or something in Bosnia, I don't want that in Google. I do legal ethics and jurisprudence in my other areas, and it's a very important aspect of this because I want to make sure this is done responsibly. Because there's so much information that people don't realize what's in it. You have no idea how many people put social security numbers in dockets. It's horrible. It's stupid. I mean, it's idiotic. And the courts just let this go through. People put really personal information in this stuff, and it probably shouldn't be there. So other things that I'm working on are trying to filter out social security numbers, personal identifying information. I just don't want that in Google because people, it shouldn't be there. Yes, sir.
one reaction is it's a little bit odd to hear one person stand up in front of a group like this and say, I don't think this information should be on the internet. And not that I agree or disagree, but it's just an odd decision-making process that you would be the person to make that decision. And so what do you think should be the decision-making process? I mean, what are the courts going to do, and what do you think the decision-making process should be?
Well, the courts are putting this online themselves, and they're not particularly interested in it. I can only speak for what information I want to put with the Google footprint. That's all I can speak for. I wouldn't be redacting documents, I would just redacting social security numbers, which I don't think serves any value. You know, if you talk to like Tim Stanley at Justia and other people in this area, they deal with stuff all the time. They get crazy to come to the door saying, we demand you take this down. And I haven't fully thought out the scope of what I want to make available. Invariably, you know, I have to make a decision, and I and the people I work with. I think social security numbers is a reasonable line to draw. I don't think indexing asylum cases serves much use. Habeas corpus, individualized data about criminal proceeding documents, I don't think that serves much use because criminal is so particular and fact specific. Maybe aggregate data about criminal law or aggregate data about habeas where all the personal information strip might be valuable to the defense bar. But invariably you have to make a decision on what you want to put up and not. And so make the decisions.
It would just be interesting to sit on you know, the judicial policy-making boards and say, what's their internal conversation about this issue?
They don't because it's very decentralized. And they have local clerks in, you know,
right, but isn't that the issue? I mean, shouldn't the courts have a more proactive way of thinking about this issue?
They should, but if you actually worked in the courts, you see the people who are doing this, it's very difficult to monitor it. There's no real check over this by anyone who has some kind of policy because there's so many things. There are thousands of documents coming in every hour. And it's just not always feasible to have it. And if you have a clerk who's making, you know, $20 an hour, they're not always going to be smart enough to read a 75-page document strip out social security numbers. A lot of the blame falls to attorneys. Frequently attorneys file stuff they shouldn't file. And it's almost impossible to kind of monitor that.
Yeah. I mean, it's a great issue because it just strikes me as, I hear you saying it's hard, and I get that, but that doesn't mean it shouldn't be an issue that should be someone consciously taking an approach with the courts on how to deal with this data and deciding what data ultimately should be made easily available and what shouldn't be so easy.
Yeah, the court hasn't made it easy to find information at all. That's not been their MO because they make money off of it.
Yeah, the court's position is that none is available.
Yeah, so they don't care. Everything there, and even if you go ahead and pay 10 cents a page and go behind their firewall, there's still a lot of information that probably should be available. You know, attorneys file documents they really should not be filing with social security numbers, credit card numbers. I mean, I was talking to Tim Stanley the other day. There's an interesting issue about copyright. In one case, someone filed an appendix, and in the appendix was a perfect scan of the first issue of Superman. It was a copyright case. So now in Pacer you have the first issue of Superman available. PDF. Is that fair use? There are serious copyright issues lingering about what people send to the courts. There's actually a lawsuit going on right now in Southern District of New York. Can an attorney copyright a brief? Someone actually sued Westlaw saying you redistributed a brief I wrote that was copyrighted. I mean, you might say it's preposterous you submit to a public court. How is this possible? But yeah, there are serious open issues.
I think that was a question over there.
Yes, sir.
I think it's great, like Dan gave yesterday, was likewise. And so it'd be great to just have more of your thoughts about 10 years from now, 20 years from now. I mean, it seems to me that this is inevitable, that all this data will be available and transparent. But I think it's kind of weird that it still is unavailable as it is. Right? And so I also thought Dan's analogy to finance yesterday was kind of informative, right? But the obvious question here is, despite all the evolution of technology and finance, is finance any better now than it was before all this stuff? You know?
I think you just move the ball. I mean, I don't think this will make law any better because now everyone on both sides will have access to it. I think what you'll have is more information about it, more ability of non-lawyers to get access to it.
Right. Yeah. So I think the lesson from finance is not whether it's good or bad. It's inevitable, right? That I think all these domains are going to get computerized, for lack of a better term. But I think the big fallout of all this computerization, particularly in finance, has been this huge disintermediation between the ultimate customer and the trading floor, right?
Yeah.
And so will that same effect occur in the law? And so, will there be a disintermediation between a consumer of legal whatever and a provider of legal whatever, and the provider being something other than a lawyer, right?
Yeah, I think that's already happening, and especially with medicine and law. If something's bothering you, Google on a WebMD, and you have a sense of what your symptoms are, you go to the doctor, I have this, and the doctor doesn't know, he goes, no, I think I have this. If you want legal services, you go to Google and you search for something, you say, oh, I think I need to follow this form, and it turns out, no, that's not right. I think you already have that, people using data, using information about technology to figure out themselves what to do, and that does create some alienation between these so-called experts. And I think this will only increase. And again, I don't know if it's a good or a bad thing. I think if there are things lawyers are charging a lot of money for that could be done simply and automatically, why not? But that does create kind of a stigma or almost a disintermediation, like your word, between the ability of an attorney to provide services and the ability of a client to want to get paid for that. They go, oh, I can do this myself. There are a lot of really deep ethical issues which I'm grappling with on my other disciplines.
And you see this, I mean, not to go on, but just to quickly kind of sort of state the obvious, you see this repeatedly in the evolution of technologies, and whenever anything disrupts, there's so much investment in the inefficiency that there's great resistance to the change, and so it has to be full. Like an IP, for instance, probably the most remarkable thing that happened, since whenever, was the Google patent search. All of a sudden, it's like, my God, you can find stuff on Google that when you talk about the Lane database, go to the patent office and search for patents in educational element. So the net of it is, though, that I don't think it's going to diminish the demand for the services, just like all the evolution of technology doesn't diminish the demand for healthcare. I think what it's going to do is it's going to raise the function of the professionals to a much higher order level of activity and performance, which is ultimately really good. But this sort of segue period is really interesting. Anyway, I think what you're doing is really.
And I guess justice for more people. Justice for more people, because right now only privileged guys can hire attorneys and go to court. So I guess I can also get justice as a poor guy.
I do think it's the whole information goes one to be free. The other thing that I think is the whole, another aspect of this dimension, which is just compelling, is the whole international dimension, right? Because we really are on a global legal playing field these days, and we see it in all the patent cases. So what are your thoughts about somehow capturing, incorporating international aspects of all of this?
I haven't looked too much at international courts. I'm guessing they're far less evolved than what we have here, maybe not. I know the UK has some pretty sophisticated APIs. I just haven't, oddly enough, I have a bunch of friends who want to start a Canadian Supreme Court fantasy league. That's about the extent of my looking to international law. But that's definitely something that could be used of how courts can interact and share law. I think that's definitely a future application. I haven't done much of it yet. Other questions?
I would just say one thing in response. It's just, obviously, if we think about the different sub-markets in law, we obviously have a substantial access to justice problem in this country, and I think on sort of welfare grounds, we can say, look, it would be a wonderful thing to be able to provide legal services to individuals at prices they legitimately can afford to pay. Without technology, I don't really see any plausible way to bring down the cost, because the delivery models of one-on-one interaction with lawyers is just not, it's got a sort of minimum price point associated with it. So folks like, hi James, LegalZone, for example, are providing one potential approach to that, and I think on that aspect of it, it's quite a good thing. You could say on the higher end of practice, it's a slightly different question, but again, this idea that there's a lot of sub-markets, and we should sort of talk about them in kind of different ways, I think.
Yeah, that's absolutely right. And Dan's doing some great stuff in Michigan State. We joke we should have traveled road trip. We've done this stick together several times back to back. He even brings the right cable setting in front of laptops.
That's true, I do. I'm their AV guy. So.
Yeah, any other questions? Thank you very much, everyone. Please, I'll be here asking questions. I'll be happy to talk to any of you afterwards. Thank you so much.
How's it going? I'm Dan. Nice to meet you. Oh, good. Yeah, I was doing what he was doing yesterday.
We're not, against legal to say that what we're trying to do is create an API and a document on this for corporations for the attorneys. Like Wilson's, we're trying with DLA Piper with this team to put their internal document in.
Oh, okay.
And, they're not gonna go to legal.
No.
So this is gonna
So
be-
you're more like, let's say, like Kayak would be like who you might be more of the market you're against.
Okay.
Right? I don't know. Is that, am I right? Is that like, you're not with, it's not LegalZoom, it's like you and Kayak are kind of going for that internal document on it.
We have it's already done, it's an automated SaaS portal.
Okay.
We're not gonna automate their documents. We're trying to streamline the whole corporation process with the Wilson Senior Cooley documents from the Founders Institute like Combinator, and we're,
I see.
and we've been on the warpath for about, since Labor Day, and it's starting to take root. Can I have a card?
Yeah, sure. I just was trying to figure out which market you were in.
We're just run corporation through the stock financing. We're not gonna do commercial.
I see.
And
Okay.
that's their bread and butter of it. Even though they do some.
Oh, yeah, right.
So how are you two linked?
What's that?
You and this gentleman, how are you two linked?
I just know him, you know. We end up getting asked to do these talks at the same place usually because they've decided that they're interested in this topic, and they usually, if you do a Google search, it's going to be Josh's name and my name will probably pop up of like big data and law. Yeah, I've got my cool card there, and then my less cool card.
Cool card. At least you don't have a.
The school gives me kind of a boring one, but
at least you don't have this cool card. Then you have little Mimo, so that basically you go like this and you drop a little.
Yeah,
Is this
that's
your
right.
startup or what is it?
That's our lab. I run a lab.
Do you make any revenue out of it or not yet?
Not yet. It's like an engineering lab in a university. This is inside of a
Do you have
university.
a comp science? I would guess you would have some comp science students.
We have I mostly have law students who have technical backgrounds involved, but I do have a couple students that do computational work in different fields. Actually, I do a lot of work with a guy who's a computational biologist who just is interested in law. So, hey James, how's it going? Yeah. Well, I was here yesterday. I gave a talk yesterday, so and I'm going to see you in a few weeks on the other side of the world, right?
Yes, if all goes well.
Do you know James?
No,
This is James.
Bad line gun.
Nice to meet you.
So
What stuff do you
we're doing the automation for the attorneys.
Oh, okay.
We're doing the legal documents portal for I'm currently with Gilly Piper and Lily and those guys. Trying to streamline what they're already doing inside. Trying to say, hey, to make versus buy, and we have an API set up, and we've got all the documents incorporated, already finished, and here all the way down to the common stock, based on the open source Senior Y Combinator and Founders Institute products. And we've been having free beta on site, and we actually would love to put our API under LegalZoom and let you guys use it.
I definitely be interested. We have a network of firms that do work for our customers, and anything that they can use to make their process more efficient.
This is and I was looking at this and like voice think about that. I thought that was brilliant. To have them go through a question and answer process.
Yeah.
And decision tree with someone like even listening on the other side. You're done.
And then just send it over. Let me check it back. Sorry, I got a little delayed.
Yeah, me too.
Oh, I'm sorry.